You might hear the term ex parte contact during your case, or the prohibition against ex parte contact. Judges may not speak to one party without the other party being present. So you can't ever call the judge's office and speak to him or her directly, and you can't call the judge's secretary or law clerk or ask that they pass a message to the judge. Any request to the judge must be in writing and served on the other side.
You will be submitting many documents to the court during your case. In general, you must give a copy of each document to the other side or her or his attorney. This is called service of process. You will also need to provide proof of service to the court.
It's very important for both sides to receive a fair hearing, and the only way that happens is if both sides understand what's going to happen in court. So if you make a request to the judge, file a motion, it's very important that you serve the other side. And serve is a fancy word for saying send the other side a copy of whatever you're filing with the court.
You need to serve the complaint and other required documents that open your case immediately after you file it with the court, along with the summons and standing order. If you don't serve the other side within 120 days, your case will be closed. If you have sent the original complaint and other required documents to the court by mail instead of filing it in person, wait until you receive the summons and standing order from the court by return mail before serving the other side all the documents. If the other side is represented by an attorney, you serve all documents to the attorney. If the party does not have an attorney, you serve documents to the home or mailing address. You must serve the complaint and summons either through certified mail with restricted delivery and return receipt requested, or by a process server. Hiring a process server is more expensive than using certified mail, but it may be more reliable if the other side is likely to refuse to sign for certified mail delivery. What if you don't know where the other side lives? How do you serve the documents that start a case, the complaint and summons? You must try hard to find the other person. This is called diligent inquiry. The Family Law Self-Help Center website has tips on how to locate someone. If, after trying hard, you still can't find the person, you may file a motion to publish notice of the case in a newspaper or in some other place where the other person might see it. When serving other types of documents, such as answers, motions, and oppositions, you can use first-class mail or hand-deliver them to the address in the court file. Serve them either right before you file with the court or immediately afterward. A motion for expedited consideration asks the court to consider your motion more quickly than usual. If you file this type of motion, you must include information on how and when you notified the other side about your request for expedited consideration. If you haven't been able to notify the other side, you must explain why. The court may not grant the request for expedited consideration unless the other side has had a chance to respond. You have to provide the court and the other side with an address where you can receive mail and a message phone number where you can receive calls during court business hours. If you do not want the other side to know your actual place where you're living, you can ask the court to keep that information confidential. You could also use a post office box. You must tell the judge in writing how and when you served a document to the other side. This step is called proof of service. If you do not submit this information, your case will not move forward and you may receive a deficiency notice from the court. Many of the forms you will use have a proof of service statement at the bottom of the form. Or you can use a separate certificate of service form available on the Family Law Self-Help Center website. On these forms, you will enter the date you served the other side, the title of the documents you served, the name of the person you served, and your signature. Remember, you must file a certificate or proof of service. If you don't, your case will be delayed.
It's very important that both sides know exactly what's happening in their case and that neither side has preferential treatment before the court. So a judge will never speak to one side without the other side being present or knowing exactly what's being said.
To summarize, the most important points about serving the other side in your case. In general, you must provide the other side with a copy of all documents you give to the court. You must follow some specific rules about how and when to deliver these documents to the other side. You must provide the court with formal written proof that you've delivered these documents. And if you don't serve the documents in the right way, or if you forget to file proof that you've served them, your case will be delayed.